You're with Wayne and Jess for breakfast, joined now by Despina Priala of Priala Legal. We're talking law.
And Despina, we've heard so much in the last few weeks about the sexual allegations, plenty of trial by social media. We haven't heard the last of it, and in fact quite a number of women have come forward since the original allegation, what's been happening in Parliament House in Canberra. A question for you. How do we get to the truth in all of this? Because there are so many aspects to it.
It's difficult, isn't it? Because when you have sexual allegation claims or charges that are brought, you're usually looking at a private situation, aren't you? You're not looking at a public arena situation. So you generally have the two people involved, the alleged victim and the alleged perpetrator. So how do you get to the truth as to what happened between those two people? So if you are going into a trial, for example, our legal system, of course, the alleged perpetrator is presumed to be innocent before found guilty, and that is the cornerstone of our legal system, and that won't change, I'm sure. But what happens at the trial? And this is the difficult part. How do you get to the truth? And we can talk about, trial by social media as you did before, and that's just wrong. I mean, people these days have so many opinions, just reading one article or two articles and already forming a view and having predispositions as to, well, I know what happened. Well, this is what my opinion is. Well, you weren't there and you don't know, and all you're doing is reading other articles that other people are posting about what they think has happened. So I think that's very wrong. And the difficult part with juries and trials by jury, of course, is that the jury has to try and ignore all of those social media articles and other information that's out there at the time through the trial.
And of course they will see it. Yeah, that's it. They'll see it, and that will have to affect how they feel about this particular case.
That's right. But I don't think a lot of people are aware. Of course, these types of allegations and charges are very serious. People are aware of that. But when you're in a trial situation, the accuser will have the ability to give evidence because they are accusing another person of a serious crime. And the alleged perpetrator does have a right to remain silent. So a lot of people may not be aware of that. So there is this issue, perhaps this evidentiary issue, when you're in a trial where, well, if the alleged perpetrator chooses to remain silent, then the evidence the only evidence that's brought forward, of course, where you have a situation between two people in a private situation, is the alleged victim and what they said happened and their account of what happened. And then it's difficult for juries, isn't it, to then determine the truth based on one side of the equation, if I could call it that, of the situation, where the alleged perpetrator chooses to remain silent.
Because there's always two sides to any story.
Yeah. Unless you're Dr. Phil. Doesn't he say there's three sides to every story? But in this case, what about when it comes to the hung jury? Is it because they haven't heard the perpetrator or alleged person speak, and we've only heard the accuser's view?
Well, perhaps. And we've seen that recently in December. There were a couple of hung juries of sexual allegations charges in New South Wales with a couple of rugby league players, and that we had some hung juries. And what that means is that the jury in those cases could not determine if the person was guilty or not guilty. They just could not decide that. And of course, in Australia, we have a situation where it is unanimous. We've got to have all 12 on the jury make the same decision, or actually in some cases they will allow 11-1 if the jury has deliberated for some time. So it's unusual, but that can happen.
That part,
yes, that's right. So, and then of course, if you have a hung jury, then you've got to do a retrial, but you can't do retrials forever and a day. It's very rare that you'll get two retrials, to be honest. So it's really hard, and the evidence is difficult for juries to actually decipher. So it is this human element, isn't it? Because you've got the two people in a private setting, and it is a he said, she said situation, essentially. And should we be thinking about this right to remain silent? Should it still be there as part of our legal system?
You hope that both would talk. But is it because maybe as they're your client, just say you're a lawyer, are you keeping them silent because they might slip up with the questioning?
Well, there is that issue of self-incrimination. So a lot of the alleged perpetrators through a trial make that decision, or just before the trial starts, make the decision, I'm not going to give evidence. I might, self-incriminate. And they've got that ability to do that. I guess my views, if I could put it, or not my views, but thoughts out there that people can think about for trials is, should we have that system? Is it fair that in those cases that the jury only hears one side of the story? Should it be that the alleged perpetrator also is required to give evidence? And in some cases they do. They get up on the stand and they want to tell their story to try and make the juries believe, obviously from their account, what happened. But some of them don't.
So do you believe they should be compelled?
Well, I think it's not really maybe what I believe. It's perhaps a school of thought that can be sort of out there in society for people to be made aware of, and maybe we should be talking more about whether it should be a different system. Is it fair for these types of charges that are quite serious to only have one side for the jury to hear? Because extraordinary claims, and I have to say that, those charges, sexual assault charges and rape charges, are very serious crimes, and that's not taking anything away from the alleged victim or victim, if it's found to be true, at all. It's just the statement that people need to realise, and this is this trial by social media. It's a very serious allegation. So those serious allegations require serious evidence. Extraordinary evidence to be able to prove that. And we do have the standard that it's got to be proved beyond a reasonable doubt for a reason, because the consequences of being convicted of those crimes are very serious indeed. And we don't want to send innocent people off to jail. So I'm not really for or against a particular side. What I'm saying is that should the system be reviewed, looked at again? Should we have the two different pieces of evidence, or sides, I should say, be given to jury? Should it be compelled to be that type of arena rather than the alleged perpetrator have the right to remain silent?
Because without that fair trial on both sides, I feel even in that public forum, if you go to speak up, you could be victimised. And so it's harder for that side sometimes to state their claim for the fact that it's like it's my word against someone who's not going to speak back to it. So then sometimes do you think that they want to remain silent? Because if their voice is heard, sometimes people say, no, you're lying, and accuse them.
Well, it's very difficult for the alleged victim. And what will happen, as we've seen undoubtedly over many years and over time, is that when someone does come forward, typically a woman, it is that is making charges or allegations against a man, that woman obviously has to relive the supposed experience. I have to say that because
shaming.
Yes, and they have to relive it, and then it's very traumatizing and very stressful. And by the time they get to trial, how they would have been and would have appeared to a jury 6 or 12 months earlier might be very different in the actual trial.
Well, they've been through the ringer, and they've had to relive it again and again and again, go over your story again and again and again. And so, by the time they've been through it the umpteenth time, you can understand why it's all just so too much almost.
It is. It can be sometimes, and therefore their evidence may not be as credible. And not because perhaps it didn't happen, but because they're so traumatised that by the time they get to the trial, they just can't relive it anymore. And sometimes that happens. So therefore, again, a question, should it be a situation that we have, and we have had for many years, and that is that the alleged perpetrator gets to choose to remain silent if they want. A lot of them don't, but they can choose to do that. And is it right in these types of serious crimes or charges or allegations that are made? Does it work in these types of situations, or sexual allegations and sexual charges and rape trials? Does it work where the alleged perpetrator has a right to remain silent? I don't know if it does. I think it just we need to talk about it a bit more, and definitely the trial by social media has to stop.
But
everyone has an opinion.
Everyone, that's right. And some people have 2 or 3 opinions. But seriously, is that realistic? To basically stop people from talking about this stuff online. can that really ever
So
happen?
many people get invested
Yeah,
in it
they
and
do.
follow the whole
They do.
story.
I think in our society, and particularly in Australia and of course overseas in other countries, people can't stop but comment on various issues on a daily basis because we have this freedom of speech and because we've always had it. And in this country particularly, you can jump on social media and say whatever you like to a certain degree. But I just think it's such a hot topic, and there are so many stories that are coming out in the media that I think it's wrong for people to jump immediately on there and say, oh, she was definitely a victim, or he definitely did it. Well, hang on a second. Let's remember the cornerstone of our legal system is you are presumed innocent before found guilty. And people have to remember that when they jump on social media and they make these comments as if they were there, as if they were in a stand watching the entire thing unfold. I think that's very wrong, and I think people need to think about that before they quickly jump on and I want to comment about this because I feel so strongly about it. Well, you might have certain predispositions yourself that colour your views.
Yeah, the worldviews that we
yes.
have from our own experience.
Yes, exactly right.
But sometimes you're so surprised that someone got off, but it's only because we've based it on an article we've read versus being in there to hear both sides of the story.
Exactly.
Which may or may not even be factual. Yeah.
Or we might not even hear that alleged perpetrator talk. Now I realise that there's that as well.
Yes, that's right. Exactly. And that can happen, and it does happen in trials, and it makes it very, very difficult. So, of course, query whether we have a trial by jury. It's always been a trial by jury, and that's in the Constitution, and I don't think that's going to change anytime soon either. But yes, it's interesting, isn't it? Very topical.
The only time we want you to get onto social media is to watch your videos. You now have a YouTube channel.
I do. All of these segments are on YouTube under my name, Despina Priala, of course, and you can view them at any time if you happen to miss the whole segment of today or any other time or any other week. But yes, they're available.
And prialalegal.com.au, they can come and personally see you too.
They can. They can ring the office and make an appointment, come and see me and the staff. Not a problem. Happy to see them.
And we'll hear from you again next week, Despina.
You will. See you then.